Hi, this is Rob Anspach, and welcome to another edition of EHeroes. Today's eHero is Angela Langlotz. Did I pronounce that right?
You did. I'm
All
an
right.
e-heroine, Rob. Not an
eHeroine.
e-hero. It's okay. You can call me an e-hero. That's fine.
Okay. Well, today's episode is going to focus on trademarks and why it's important to protect your online digital content. So welcome to the show.
Thank you. Thank you so much for having me. I feel honored to be an e-heroine for the day, if only for 25 minutes or so. It's
That's
cool.
right. So,
Glad to be here.
you're out of what, Dallas? And
Yeah, I live in Dallas, Texas, but I was born and raised in the great state of Oregon, where it will continue raining for the next 5 months or so.
yeah, well, I'm sick of rain. I'm sick of snow, and I'm in Pennsylvania.
Yes, well, I'm sorry. I'm sorry.
So let's talk about trademarks. I mean, you go by the name Trademark Doctor. How did that come?
Yeah, a Trademark Doctor is just a website that I created. I just thought the name was catchy, and it lends itself to all sorts of naughty innuendo too. So that's always fun. But Trademark Doctor is basically the resource. The website trademarkdoctor.net is the resource for entrepreneurs if they have trademark questions. So I have a whole video library there. There's an FAQ. You can contact me and schedule a consultation. There's a whole bunch of resources there because people have a lot of questions about trademarks. And I see online entrepreneurs, especially, trip over the same issues over and over and over again. And it's just too painful. So I decided, why not? Why not a resource? And so trademarkdoctor.net was born.
Well, what are some of the biggest misconceptions, I think, with trademarks? Because I think people confuse trademarks with copyrights.
Oh yeah, they confuse all three types of intellectual property. So there are patents, there are trademarks, and there are copyrights, and they confuse all of those, and it becomes this word salad of different terms. But in essence, a trademark is anything that distinguishes your goods and services from other people's goods and services. In contrast, a copyright is only for creative works reduced to a tangible medium. So it's anything that you can reduce to a tangible medium. That's also creative. So for example, a photograph, a poem, a book, a translation of a book, the arrangement of the lights on the Eiffel Tower is actually protected by copyright law. So if you take a photograph of the Eiffel Tower at night, you are actually making a reproduction of somebody else's copyrighted work, and you are a copyright infringer. So just fun trivia, right? And in contrast between the two of those, a patent is something that protects a useful invention, like maybe a business method, like Amazon's one-click checkout is actually protected by a patent. It's a business method, right? Obviously things like, you can patent plants, you can patent drugs, you can patent basically anything that's useful, novel, meaning it's new, and non-obvious, meaning it wouldn't be obvious to the general public to do X, Y, and Z, right? So those are the differences. And people get those confused a lot. To make matters even more complicated, we have copywriters, people who write sales copy, which is not the same thing as getting a copyright for your protected material, although your sales letters are certainly protected by copyright law. So if you are a copywriter, you can get a copyright on your material. How confusing is that?
Now, is there a time frame that certain patents or trademarks or copyrights extend to?
Well, a patent lasts 20 years from the date of your application, right? It used to be 17 years from issuance. Now it's 20 years from the date of your application. A copyright is good for, so a work is protected by copyright, even if you don't file, and that work is protected for up to 75 years after the death of the creator. So we want to make sure in that law that the creator's heirs essentially have the right to profit from the creator's creation. Trademarks will last for as long as you keep using them. your trademark registration, so if you have a registration, you need to renew that between years 5 and 6, and then again between years 9 and 10, and then every 10 years thereafter, you have to keep renewing that trademark, and you have to keep using it. If you keep renewing it, but you're not actually using it, you're committing fraud on the trademark office, and you can actually lose your trademark for fraud. That's grounds for trademark cancellation. So basically, as long as you're using a trademark, you can continue to own the rights to that mark.
Now, how do you protect that, though?
Well, you can protect it. Do you mean protect it by, you have to police it, right?
Right.
So if you see somebody else who's infringing your trademark, you need to make them stop, because the trademark gives you the exclusive rights to your distinctive mark. But if you let other people use it, your mark is no longer distinctive and it will cease to serve as a trademark, right? So you want to make sure that if you see naughty infringers, you have to make them stop. Another good thing to do is to actually register your trademark, because if you don't register your trademark, somebody else can actually apply and get a registration for your trademark, because the trademark examiner doesn't know that your mark exists unless it's in the trademark database. So if it's in the database, the trademark examiner, in essence, kind of acts as your own little trademark watchdog, and they will refuse to register conflicting marks. So that's a very good reason to register your marks. There are others as well. But that is one of the biggest ones. And I see all kinds of conflicts where people go, oh, well, I have common law trademark rights. You actually have rights, even if you don't register in the geographic area that you're using the mark. But the problem is maybe other people don't know about that. So they go into the trademark office, they file an application, the trademark examiner says, oh, everything looks fine, I'm going to go ahead and give you a registration. And now, even though you're the first user, because you didn't register, you are put in the uncomfortable position of having to assert trademark rights without the presumptions, the legal presumptions that the naughty infringer / new trademark registrant now has. So they've kind of got the drop on you, right? And now it's going to cost you a whole bunch of money to prove all of the things that you need to prove that you were the first user and you're the rightful owner of the mark. It's a big pain in the butt. It's so cheap to get a registration. It's less than $1,500. Why would you not do that, considering how expensive it is to hire an attorney? Not to mention the prospect of, if you lose, you have to rebrand. How much is it going to cost you to rebrand?
Now, is there a difference between a global trademark and a regional trademark?
Okay, well, there are state trademarks, which to me aren't really worth the paper that they're printed on, because you're pretty much going to get common law rights for you'll get common law rights for your geographic area, depending how big your state is. That may or may not get you the entire state, but a state trademark only gets you rights in your state. Somebody else can still go in and file for a federal registration, in which case they would have the right to use that mark in every state except maybe the area that you're using it in, right? So federal trademarks trump everything. Right. So you can get a state trademark. I don't like them. I think they're disfavored. I don't like them because I don't think they really get you very much. I think you're much better off filing a federal registration if you're doing business, especially if you're doing business on the internet, because the internet is kind of, ab initio from the beginning interstate commerce, right? So you have to be using it in interstate commerce. But if you're selling stuff online, you're exposing people in every state in the union and worldwide to your brand. Now, if you want to get a registration in other countries, you can. There's this thing called the Madrid Protocol, which basically allows you to file one application in multiple states. And when I say states, I mean countries, right? But they're called states under the Madrid Protocol. And it's pretty expensive, though. So just because it's easy to file one of those unified applications, you've still got to pay in every country. And unless you intend to have a global brand, and most small entrepreneurs don't, and the biggest market in the world is right here in the good old USA anyway. So I have a lot of foreign clients that sell in the United States that want US trademarks because their biggest market is here in the United States. So yes, you can get a foreign trademark registration. Policing that might be problems. We have a lot of problems with, knockoffs from China. They appropriate people's brands all the time. They sell, crappy Louis Vuitton knockoffs. And, that's a trademark infringement right there. Of they have their logo, they have their name, they have their checkerboard, the whole thing, it's a mess. So it's very sometimes hard to monitor those trademark rights outside of your home country, and it's also very expensive. So anytime I say something's hard, translate that into expensive, right? So if you have to prove stuff and it's hard to prove it, it's expensive to prove it. You might just as well stand on the front porch and light $100 bills on fire, because that's what it's going to cost you.
So let's talk about a global brand like Walt Disney. They own all these characters. They just bought, over the years, they bought Pixar and Disney and Marvel and,
yep.
and you name it. They have to have buku bucks just to keep all those characters, registered constantly.
Yep, they have an army of in-house trademark counsel and, probably outside trademark counsel and litigation counsel as well, who are monitoring all their brands globally and doing their best to quash any naughty infringements. It's like playing whack-a-mole, Rob. Remember that game, whack-a-mole? So, you're always going to have people who are trying to infringe your trademarks, and you're always going to have to be after that. If your brand is valuable as Disney's is, and as valuable as those characters, Elsa and all of the princesses and all of that, as valuable as those characters are, you bet they're going to spend whatever they need to spend to ensure that they continue to have the exclusive right to those trademarks.
So how does an average person, like you and I, that we don't have a global brand, we have more of a brand that maybe people in the United States will recognize.
Mm-hmm.
How do we protect our online intellectual property?
Well, I think the first thing that you need to do is make sure when you brand your own stuff that you're not stepping on anybody else's toes. I see a lot of this. So I see a lot of problems with people adopting brands without checking. I see this a lot with Amazon sellers, and they'll come to me and they'll want to register. They've branded without benefit of legal advice. They've branded, some line of goods that they have, and now they're trying to get a trademark registration. Well, they've chosen a brand that's merely descriptive for their goods. Like maybe they sell coffee products online, and their brand is something like, coffee supplies, right? I can't register that. It's merely descriptive. And so they'll come to me and they'll say, oh, we need to register this because I need to be in Amazon's brand registry and I need a registered trademark. And I'll say, well, you can't register that. It's not really registerable because it's merely descriptive of the goods that you're selling. That's the rejection that I'm going to get from the examiner. And having filed hundreds of trademark applications, I know that is the number one most common objection that I get. And it's because people don't know what they're doing when they brand this stuff. And, of course I get pushback from them and they're not very happy to hear that, but it's not my job to tell them what they want to hear. It's my job to actually get them the property. They don't hire me because they want to, stand on the front porch and light $100 bills on fire and pay me and pay the filing fee and get rejected. They want the property. So it's my job to tell them the hard news. And that's frequently, you're going to have to rebrand because this won't fly. The other thing that you need to do is if your brand is really important to you and it would upset you to see another competitor using it or have somebody else register it and you be forced to stop because you don't have the money to fight them, then be proactive and get a trademark registration. Pick a good brand, get a registration, and then police that registration. If you notice other people are getting close to your brand, your rights don't just extend to your actual trademark. They extend to anything that would be confusingly similar for the consumer. So if a consumer would stand in the aisle and be confused as to the provenance of your goods versus your competitor's goods, then that's confusingly similar, and you need to make them stop. Because once your mark isn't distinctive anymore, you don't really have trademark rights, because the whole point of trademark law is to enable consumers to distinguish one company's brands from another company's brands. We want to know, where does this brand come from? What do I mean by that exactly? For example, I know if I see a shoe and it's got that Nike swoosh on it, I know that that shoe isn't going to fit me because Nike makes really wide heels and they slip off my heels, and that's very annoying to me. So I'm going to look for the 3-stripe shoe instead, right? I'm going to buy the Adidas shoes because I like the way those fit better. But that's the point of having a brand. Your brand exemplifies certain qualities that you're trying to transmute. You're trying to inform the consumer. This is what we're all about. You know, we're all about the narrow heel counter here at Adidas, not the big wide blabby heel counter like they have at Nike. I mean, they don't actually say that, but I know this because I'm a consumer and I've experienced both brands. So I want to know what I'm getting. So it matters to me where the shoe is coming from. So if I'm confused between Nike and Adidas, or Adidas, or however it is they say it, I say Adidas, whatever. If I'm confused, maybe I won't make the right, I won't pick the shoe that's right for me. Do you see where I'm going with this?
Mm-hmm. And for the record, everybody, I'm actually wearing Adidas right now. So what's the time frame? I mean, when someone comes to you and says, I want to register a trademark, how long does it take?
Well, the answer is, I'll give you a very legal answer, and it depends, right? If nothing happens, if everything just goes whoosh right on through, and I don't get any office actions from the examiner, and I don't get any protests from any third parties who think that the mark being proposed is too close to theirs, then 9 months, right? 9 months. I know people are always astounded when I tell them how long it takes, but just keep in mind a couple of things. The trademark examiner is not even going to look at the application for like 4 months. It goes into the queue and it gets seen in the ordinary course of business over there at the trademark office. And that usually takes about 4 months because everybody else is filing trademarks too. So the examiner looks at the mark, and if they don't find anything that is a problem, I get what's called a notice of publication. Okay, so I get a notice of publication, and it says, hey, we didn't find any reason to disallow your mark, and now we're going to publish it so that the rest of the world can weigh in. And so it's published in a publication called the Official Gazette of the Trademark Office, and the rest of the public has 30 days, and you can extend that. If you need more time to protest or oppose the trademark, you can extend that time, but they have 30 days at least to, to say, oh, hey, wait, we think that this mark is too close to ours. If it goes through both phases of that and there aren't any problems, then it gets issued in, 9 months, right? Sometimes a little sooner. Sometimes a little later.
I get that notice of rejection.
Sorry, if there's a rejection, so there could be a number of rejections. The rejection could be, the examiner could tell me a number of things. They could say yes, but they could say no, or they can say yes. So we already covered yes. Yes, but is, yes, I don't see any reason to disallow your mark, but I need you to provide me with a better specimen. And a specimen, I know it sounds like that thing that you leave for the doctor when you go visit, like the doctor says to you, we need a specimen, right? Well, the trademark examiner needs a specimen too. Not that kind of specimen though. What they need is they need to see how you're actually using the mark. And sometimes what I think is an adequate specimen and what the trademark examiner thinks is an adequate specimen, there's some variance between those things. And sometimes my experience has been that the examiners are unreasonably stupid and stubborn, but it just happens, right? they're humans and we deal with them just like everybody else. We have to put up with them. So I will work with the trademark examiner to find a specimen that is acceptable to him or her. And sometimes that's challenging depending on how unreasonably stubborn or stupid the examiner is. So if that's the case, now we always have 6 months to respond to anything the examiner sends us. And when the examiner sends us something, it's always called an office action. All right. So they will send us an office action. We have 6 months to respond. Of course, I want to respond as soon as possible because I want to keep this application moving forward. I don't want anything to hold up the timely processing of my client's application. So I will go right back to the client and get what I need, or I will respond to the examiner's office action. The other thing that the examiner can say is no. And the no is, I think your mark is too close to someone else's mark. Therefore, I'm going to give this the big no. Thank you. And I always have the opportunity to answer. Now, I wouldn't have filed the mark in the first place if I thought it conflicted with someone else's trademark. So sometimes I have to do some research and writing in order to prepare the response to office action that is required in such a case. And occasionally I'll go a couple rounds with the examiner, and occasionally I will have to file an appeal before the Trademark Trial and Appeal Board in order to get this mark through if I think the examiner is being unreasonable. So those are the 3 things that can happen. That's the yes, but, and the no.
It's a lot of work.
It is a lot of work. It is a lot of work. And I think the major misconception that people have is that, oh, you should just file your trademark application yourself. It's super easy. And they are right that filing the trademark application paperwork is super easy. But the thing that you have to do before you file your application is you have to make sure that you do a good search. And this is where most do-it-yourself entrepreneurs completely mess up, because they don't really know how close they can get to someone else's brand before it's confusingly similar. So people seem to be under the mistaken impression that if my goods aren't exactly the same and my mark isn't exactly the same, it's fair game. And nothing could be further from the truth. Your trademark rights as a trademark registrant extend not only to your goods and services, but to anything that is kind of within your realm of goods and services. And they also extend to marks that would be confusingly similar to yours. And there are a whole bunch of factors that go into this confusingly similar calculus, right? So, and I go back and forth with people all the time. Oh, but I got this. They'll come to me after they've already gotten the rejection, right? Oh, well, it's not exactly the same. So I don't understand how this could be, confusing and da, da, da. And I'll just say, listen, given the record, because I go in and I search the record, I look, I see what's out there, and then I evaluate how close is it? Is it a live mark? Is it a dead mark? What are some other factors? I may actually go in and look at the record to see, how did this mark proceed, and what can I glean from that? So there's a lot that goes into doing a good search. And these trademark outfits that will file your trademark application for $99, rhymes with boom, legal, they will indeed file your trademark application really cheaply. But what they don't do is they don't do anything but an exact match search. So they will go in, and if they don't find the exact match for your mark, then they will file the application. However, there could be other stuff out there, and there almost always is, because people don't tend to be very creative about their trademarks. There is almost always stuff out there that will be a reason why your mark will be rejected, because you only did an exact match search. If you read the fine print that Legal Rhymes with Boom puts out there, they'll say that if you want a better search, a more thorough search, then you're going to have to join their, I think they call it their yearly legal program or something. Anyway, you might just as well get it done right the first time, because what's going to happen if you don't do it right the first time is you're going to waste the filing fee. You don't get that back. You're going to pay Legal Rhymes with Boom, and you don't get that back. And you're going to waste at least 4 months, and you're definitely not getting the 4 months back. Okay. So it's not really expensive to, to hire a competent attorney to file your trademark application. And you really should do that, and make sure they're a trademark specialist too, because I see a lot of messed up filings from generalist attorneys who, while they charge more than legal rhymes with boom, don't actually add any more value to the process because they have no clue what they're doing. So, I mean, you really need to hire the right person to do this and make sure that they know what they're doing. So interview the attorney before, you hire them. Find out how many applications they filed. Find out if they, do they do this every day? What's their experience? Because you wouldn't hire somebody to, operate on you, cut you open without knowing what their skills and attributes were. So, interview your attorney the same way. Just because it's cheap doesn't mean it's the right thing.
Sure. I mean, you're protecting your intellectual property. Why go to someone that doesn't really know what they're doing?
Yeah, I wonder that all the time. But people, some people, they just want the cheapest, and that's fine. Those people probably don't make good clients, at least not for me. Maybe other attorneys like those clients. They probably don't. But, you can't talk sense to these people because they don't see the value. And that's fine. That's fine.
So
God bless them.
how do the listeners or the viewers, depending on where they're watching,
Mm-hmm.
how do they get a hold of you? I mean, I know that you have a website. I know you do
I do
Facebook
have a
videos
website.
all the time.
I'm on Facebook. I'm Angela Langlotz on Facebook, and I do have a website at trademarkdoctor.net. And on the contact page, there is a consultation link, and I will talk to people for 15 minutes about general trademark law questions, if that's what they want to talk about. If they want to like get advice on their dog or what they should buy their wife for their birthday, I might just talk to them about that too. But it's primarily for trademark law, trademark and copyright law, and those kinds of questions. So, they can do that. But that's where you can find me. I am on the internet. I am wired, Rob. Wired.
Wired. Hey, we have a few more minutes, but let's talk about cyber squatting, because
Oh God.
that's irritating me, and
Me too.
I can't stand it.
Oh, these people are ridiculous. You know what? It irritates me because cyberspace, that's very, very valuable real estate, right? It's valuable real estate. And people come to me all the time and they'll say, I'm trying to get this domain. Is there anything I can do? And my question to them is, do you own the trademark? And they'll say, no. And I'll say, sorry, you're out of luck. You're just going to have to get them to sell it to you. If you already own the trademark and somebody goes and gets the .com, and shame on you for not getting the .com first before you actually applied for your trademark, but that's neither here nor there. People do all kinds of crazy stuff. If somebody registers your .com or .net or .whatever after you've already gotten your trademark registration, then you have rights. Then there is actually a way to force them to transfer that domain to you. But if you don't already have the trademark application, I'm sorry, you're stuck, right? So I'm frustrated by it too.
Yeah. So, guys, girls, everybody who's listening, protect your intellectual. And you see, I do this all the time. Even on my live videos, I mess up one word. So protect your intellectual content by calling Angela, by going to her website, by watching her live videos.
Yeah, I'm live every weekday talking about all these questions because we talk about some fun stuff too. Like a couple weeks ago, we spied on Kylie Jenner's trademarks. That was kind of fun and illustrative. Also, I mean, I get these ideas just walking through Costco. I was walking through Costco. I was about to buy roast beef and I saw, those big green egg barbecues. Well, I saw a big blue egg. Right. So that got me thinking, that got me wondering, hey, I wonder if Big Green Egg has a registered trademark for green for barbecues. And I went live and we snooped on their trademarks and they did. Big Green Egg actually owns the trademark green for barbecues. Nobody else can make green barbecues. True story.
So they have to make the blue ones.
They have to make the big blue ones, right?
Or yellow or pink.
Or yellow or pink or orange or black or any other color, but they can't use green.
So if you guys want a big green egg, you can't do it, go with pink.
Right? Yeah. Go
Open
with
up
the
your,
pink egg. Go with the pink egg. You know, Owens Corning actually owns the trademark pink for fiberglass insulation. Did you know that?
I did not know
No
that.
one else can make pink insulation.
Well,
Belongs
I
to.
don't know if I want to buy it any other color. I think we've kind of been ingrained in that.
Oh, you see it. You see it in like baby poop beige all the time.
Yeah, no, that's a disturbing image.
I know, right?
We're going to end on that note.
Oh, really? Okay, I can't redeem myself, Rob. You're cruel.
Uh,
Cruel. All
Redeem, you got a minute. So
right.
what's one thing that the audience should do right away, for their intellectual property, that might be cheap?
Might be cheap. The cheapest thing you can do is, go do a good search. Well, you may not know how to do that, so it might not be cheap. What's the cheapest thing you can do? The cheapest thing you can do from a litigation prevention standpoint, and that's always much cheaper than litigation, is just go get a trademark registration, right? I don't care if you have me file your application or not, but at least, go get a trademark registration for the brand that you're actively using and promoting. Because otherwise you may have to abandon it later, rebrand. It could be ugly, and that's all expensive. So
See, there you go.
yeah.
So visit her page and watch her videos. And this is why Angela is an e-hero. So you guys.
Hero.
Yeah.
I want a halo. I want a halo.
Halo. No, I don't have any halos. I can get you a cape or something. But everybody, stay tuned for future episodes, and we'll see you back here soon. Adios.